There are many options for a client that is in debt and wants to get out of debt. The two main options that clients are always struggling to consider is debt settlement or bankruptcy. And really, depending on who you ask, you're going to get different answers. If you ask a debt settlement firm, they're going to tell you that debt settlement is the best thing in the world. If you speak to a bankruptcy attorney, they're going to tell you that bankruptcy is the best thing in the world. Well, the good thing about the Gershfeld Law Group is that we do both. So we really have no interest in pushing our clients towards one or the other. We really will look at the client's situation as a whole and determine what is the best, most comprehensive option for that particular client's needs. There are two different kinds of bankruptcies. Debt settlement is probably more similar to a Chapter 13 bankruptcy. So debt settlement is basically the process of negotiating with creditors to reduce the overall principal amount of the debt. So you're actually paying back a portion of the debt, not the entire debt. Chapter 13 kind of works the same way, where you're paying back a portion of the debt. However, with a Chapter 13, you're actually paying back a much larger portion than you would be with debt settlement. Also, with debt settlement, the programs tend to be shorter. So with debt settlement, you have an option of being in a short program as short as 6 months, or the longest program would be 4 years. With bankruptcy Chapter 13s, they tend to be between 3 to 5 years. So not only are you in the program longer, you're actually paying back a bigger portion of your debt, which ultimately means the payments will be much higher for clients. So it's much more difficult for clients to stay in a Chapter 13 and actually get discharged through a Chapter 13. Many clients will fall out of it because they can't make the payments over such a long period of time. With debt settlement, there are no upfront fees, so there's no risk to the client. We don't make any money unless we actually succeed, settle the client's accounts, because we operate on a strict contingency. With bankruptcies, both a Chapter 7 and a Chapter 13, you have to pay money to the attorney to file the petition up front. So most attorneys will not even file your bankruptcy petition in court until you first pay the full fee up front. And it can range from $1,000 to $3,500, and usually a lot more than that, because there's always law in motion, different kinds of paperwork that has to get filed, and oftentimes the fees will be significantly higher than that. So in many situations, particularly with the Chapter 13, most clients do tend to fall out of them and they don't complete the full program. So the money that you pay the attorney, once your bankruptcy gets dismissed, you don't get that money back. Whereas with debt settlement, there is no risk. You pay nothing up front, and if we don't perform, you don't pay. Debt settlement is completely transparent as a program, and the client has complete control over all aspects of the program. So the client gets to decide how much they're going to be able to pay, how long do they want to be in the program, whether they even want to accept the settlement offer from the creditor. The client is presented with the offer, and the client could always say yay or nay. No, I don't want that settlement because I think I can do better. With Chapter 13 bankruptcy, you don't have that option. In fact, when you file a Chapter 13 bankruptcy, the client has to be prepared to give up complete control of their lives for pretty much 3 to 5 years, complete control over their finances and any decision having to do with their finances. The client does not get to decide how much they want to pay. The court will decide. The client does not have a chance to decide whether they will accept the settlement from the creditor or not. Whatever the court says they pay, that's what they have to pay. So there really is no control. And for 3 to 5 years that you're in a Chapter 13, you have the court and the bankruptcy trustee pretty much breathing down your neck, telling you what to do with your life and your money. I think people are just not really informed about those risks. Nobody tells them about the fact that they're giving up complete control over their lives, particularly with the Chapter 13. So I think people are just misinformed. And if they knew what their options were, I probably think they would never choose that route. Most clients that have the financial ability will choose a shorter program because, generally speaking, the shorter the program, the bigger the payment. So some clients just have no choice. Some clients need to go in a longer program, but they can range from anywhere from 6 months to 4 years, whereas with Chapter 13 bankruptcy, the minimum program is usually 3 years, and most programs are between 3 to 5 years. But the bigger problem is that the payments are just so high because you are paying a larger portion back, and you have no say. The court will decide what you need to pay, how long you pay it, and how much you pay. Debt settlement is very flexible. The client can make payments or sometimes not make payments if they can't. So for example, come December, and I have a client calling me saying, Yana, please, I need to have money to buy Christmas presents or Hanukkah gifts. Can I please miss my December payment? And of course, we'll say yes. To the extent that we can, we will try to accommodate the client because we understand that life happens and Christmas happens, and sometimes unexpected events happen where they have car problems, they need that extra money so they can't make their payment on that particular month, we will try to accommodate them as much as we can. With bankruptcy, Chapter 13, there is no such option. You cannot miss payments. You are in the program, and you have to stick to the program for the entire length of the program. Also, while both debt settlement and bankruptcy to a certain extent will affect your credit, bankruptcy will affect your credit severely and much more so than debt settlement would. The overall impact to your credit with the bankruptcy is greater. Not only that, bankruptcy will generally stay on your credit report for longer. With debt settlement, and negative items on your credit history will usually stay on about 7 years, and very often creditors will remove them even faster. Whereas with bankruptcy, Chapter 7 bankruptcy will stay on your credit for 10 years. And even though Chapter 13 bankruptcies are supposed to stay for 7 years, because they often get dismissed, they would stay on for as long as 10 years as well. What's really important to understand also is that it is completely private. Nobody knows that you're in a debt settlement program but you and us. It is completely private, nobody has to know, and that's really important for our clients who are already pretty embarrassed by their situation, and they really don't want anybody knowing that they're struggling. Bankruptcy, on the other hand, it's a matter of public record. It's for the whole world to see and scrutinize because it's being filed in the court of law, and it's a matter of public record. So that's another really important consideration for people who are concerned about their privacy being violated or people knowing their business. Most people are not aware of the fact that with bankruptcy, oftentimes filing a bankruptcy can have potential negative consequences on your work or business. So, for example, if you have a professional license or you want a professional license, you may have a hard time getting it with the bankruptcy filing on your record. Or if you have a business and you need to apply for a business bond, you may have a hard time getting qualified because of the bankruptcy. So that's another important thing to think about when you are contemplating doing debt settlement or bankruptcy. Chapter 7 is another kind of bankruptcy, also known as liquidation bankruptcy. And that's basically where you are able to completely liquidate or discharge your debt completely. So you pretty much walk away owing no money to your creditors, you walk away with a clean slate and a fresh start. And it's a wonderful option for many people. However, it's based on a big if you qualify. So in order to qualify for Chapter 7 bankruptcy, you have to make very little or no money. There were recent changes to the bankruptcy code back in 2005 or 2006, and that's made it a lot more difficult for people to qualify for Chapter 7 bankruptcy. So if you qualify, it's a wonderful thing because you can get a complete and full discharge. But it's also important to understand that you don't get to have your cake and eat it too. So you don't get to walk away completely scot-free, not owing your creditors anything, and then keep all your items and property and assets. So with the Chapter 7, because it is a liquidation, you have to liquidate your assets. So any non-exempt assets that you owe, you would have to sell them, and then the proceeds from that sale would get distributed to your creditors by the court. So you do get to start over, but you really have to get rid of all of your non-exempt assets and truly start over.